May it please the Lordship.
Yes.
Lordship, I beg to mention hearing item number 15, my Lord.
15. You had
Yes, my
moved an
Lord.
adjournment slip.
Yes, my Lord. Yes, my Lord. My Lord, my senior is in bereavement. So, if this matter can come up after 4 weeks, my Lord. I have taken the consent.
The learned counsel for the petitioner is stated to be in bereavement, and a prayer is made for listing this matter after 4 weeks. Prayer allowed. List the matter after 4 weeks.
Obliged, my Lord.
Lordship.
Yes.
Lordship, I'd like to mention hearing item number 13 and 14.
13 and 14. Yes.
Lordship, I pray that you let this matter come up after 3 weeks, as my senior is having some personal difficulties.
One is an appeal of 2014.
Yes.
The other is of 22. You are appearing for the appellant.
Yes, Lordship.
You are your name?
Mapili.
Okay. It is prayed for the it is prayed on behalf of the appellants to list the matter again after
3 weeks, Lordship.
3 weeks. Prayer allowed. List the matter after 3 weeks.
Obliged.
May I please, Lordship? My Lord, allow me to mention item number 4.
4.
Yes, my Lord.
Yes.
I have received a objection filed by the respondent number 2. I may be allowed to file a short reply. Allow me 2 weeks time.
It is submitted on behalf of the petitioner that they have received a copy of the objection filed by the respondent number 2 today morning itself. Hence, it is prayed that 2 weeks time may be afforded to file a reply.
Yes, my Lord.
Prayer is allowed. List after 2 weeks along with the reply filed by the petitioner.
My Lord, there is an interim. If that may be allowed.
Interim order will continue till the next listing.
Obliged,
Interim order
my Lord.
continues. Next listing too. Interim order continues.
May I please, Lordship? Lordship, I beg to mention hearing item 11, Lordship.
11.
Lordship, I beg gracious if this matter may come up after a week, Lordship.
2018.
Lordship. Lordship, since we are under preparation for the argument. Lordship.
Learned counsel for the appellants seek some time to prepare the matter thoroughly. Accordingly, list the matter after 2 weeks.
Lordship.
2 weeks?
Lordship. Much obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item 2.
Item?
2.
2.
Lordship, on behalf of PPJ3.
Yes.
Lordship, the leading counsel is not in a station. Let the matter be kindly come after 2 weeks.
2 weeks.
Yes, Lordship.
It is submitted on behalf of the learned counsel for the appellant that it is he or she, he, that he is not able to attend the court as he is out of station. List the matter after 1 week.
2 weeks.
2 weeks.
Vice Mayor.
Please, Your Lordship.
Yes.
I'd like to mention item number 1. Admission item number 1.
Item number 1.
Lordship, my senior is out of station due to personal circumstances. Kindly list this matter after 3 weeks.
You are an interim. You have an interim in your
I'm for the petitioner.
Yes. There is an interim
Yes.
order in.
Yes, Lord.
You are for the respondents. You are pray for the respondents.
Having
Respondent
responded,
number how much?
Respondent number 2.
the father of the leading counsel is not keeping well. I'm informed this morning.
Okay.
So,
On a joint prayer made by the parties, list this matter after
3 weeks.
3 weeks. Interim order, if any, shall continue.
highly blessed.
For motion from the supplementary course list, item number 16. Is it?
May I please, Lordship?
So you keep this with the file, item 15. Yes,
May I please, Lord? My Lord, this is the application praying for amendment of the prayer. My Lord,
yes,
yes. And the main petition also listed today, item 7.
7.
Item 7 in there. Item 7 in the or
It has come up for motion.
admission.
No, this IA has come up for the,
Yes, I have served copy to both council.
you want to file objections?
Yes, I'll be filing, I have strong objections in fact, my lord.
You don't have any objections.
Yes, to the IA, because they are trying to alter the petition, my lord. Initially, they will,
Yes.
they have filed for quashing the investigation and quashing the FIR. Now, during the
Charge sheet
pending-
has come.
Yes,
So now
yes,
they want to challenge the charge sheet in the
Yes, my
same
lord.
petition
yes, my lord.
and you don't have any objection.
I have strong objections, my lord.
We give him some time to file his written objection.
No problem, no problem.
I'm appearing for respondents 5, 6, 7 and 8, my lord. However, my lord, I have a special request, my lord. The leading counsel, she's from Delhi, the Supreme Court, Binta Prober. And she has made a request that if the matter can be posted immediately after the puja, that is on 6th of October.
So can we do it this way? We allow them around 3 weeks or 4 weeks time to file the objection.
My lord,
To the, we'll allow you time to file the objection in this IA,
my lord, my lord.
right?
Lordship.
So on you filing an objection, I think they'll require to file a reply. So that is 2
There
months.
cannot be any fixed
By
date.
the time it comes up for consideration, I think it is somewhere near puja.
My lord. Lordship.
Filing of objections, I don't think the leading counsel has to participate. You can do
Yes,
it.
my lord. Lordship, but if then a fixed date can be given after.
No,
Cannot.
you're not getting me. Today I will give you an opportunity to file your
Lordship,
objections to the IA.
Lordship,
No fixed date, we'll keep it after 4 weeks.
Yes.
You file your objections, matter will be listed. They may like to file a
Absolutely.
reply to your objections.
Absolutely.
Lordship,
Thereafter, the matter will come up for consideration
Yes.
whether we allow the amendment or not. By that time, you take a fixed date. We don't give a fixed date today. We give a fixed date then. This interlocutory application has been filed by the applicant, who is also the petitioner in WP criminal number 10 of 2025,
Yes.
making a prayer to be allowed to amend the prayers made in the writ petition.
Yes.
Copies of the interlocutory application has been served on all the contesting respondents,
Yes.
my lord.
and therefore no formal notice is called for. The counsel for the respondents pray for some time to file their objections to the interlocutory application. List after 4 weeks.
After 3 weeks, my lord.
After 3 weeks, allowing the respondents to file their objections to the interlocutory application. Mr. You want a fixed date after this? Should I give you a fixed date? List after 3 weeks, is there, no? List after.
Much obliged.
Much obliged, my lord. My lord, the main petition which is listed
Yeah.
at item 7.
Item
Yes.
7, main petition.
Item 7. I have item 7.
If it may also come out after 3 weeks along with the IA.
Item 7 पे लिखिए. Take down in item 7. An interlocutory application
17.
has been filed. An interlocutory application being IA criminal 17 of 2025 has been filed where the respondents have been allowed to file their written objections by an order passed today. In view of the above, list this writ petition along with IA 17 of 2025 after 3 weeks on a date to be fixed by the registry.
Much obliged.
Deeply obliged.
Thank you.
For motion, item number 17.
May it please your lordship.
Yes.
There is an appeal against the conviction order dated, judgment dated 10/1/2022 in a POXO case, my lord. And this case has been referred to me by the High Court Legal Services Authority, the Nagaland State Legal Services Authority, my lord. We have a panel here, and I'm also one of them. So, my lord, the IA that is to be considered today is for the condonation of 879 days.
When was it forwarded to you?
My lord, it was forwarded to me on 11/5/2025. You know,
Yes.
IA 18,
I-18, yes, I'm having I-18. Where have you stated that?
that letter is at page number 28, my lord. The last page of the IA 18.
Page number 28, yes, PP.
My lord, annexure 2.
Lordship, since there
Person is
is a
in jail.
delay of 879 days, Lordship, I am allowed to take an instruction, Lordship.
Your lordship.
By next week or
Next week, Lordship.
by next week?
Next.
This interlocutory application has been filed praying for condonation of delay of 879 days in preferring the connected criminal appeal against the judgment dated 10/1/2022. Can you take it from page 1 of the appeal? I am marking it A2A. Okay, take it from here. Mr. So-and-so, learned PP, Nagaland, 10 days time?
Lordship.
10 days would be when? 1, 2, 10 days time to have instructions. Yes, choose your date. There's no difficulty. Choose a date. When do you want it?
On 26th.
10 days time to have instructions in the matter. Accordingly, list the matter on 26th. By which time objections, if any, may be filed.
Lord.
And the matter for condonation of delay in filing the criminal appeal shall be taken up. Man is in.
Lord.
He's facing the sentence, is it not?
Lord.
There was a delay on the part of the legal aid.
Oblige your lordship.
Yes.
For motion from the supplementary cost list, item number 18.
Item number 18. Yes.
May I please, Lordship? Lordship, this has come for the first time for
Yes.
condonation of delay.
Notice.
Lordship.
You need to be a little bit more specific. See, if you come to page 6,
Lordship.
this goes totally against you. I'm not even inclined to issue notice on this. Can you read from 1, 2, 3, 4, 5, 6? 7th line from the top starts with the word proceeded ex parte and was fixed for judgment.
Yes, Your Lordship.
Then read the sentence. The regional office, please read the sentence.
The regional office at Gauhati, on receipt of the judgment dated so-and-so from its penal counsel
Now,
based.
what happened between 23 and 25? Your original appeal,
Lordship.
you had taken time to explain the delay because the court was not satisfied.
Lordship.
At the time of dismissal of the matter, there was no affidavit on record explaining the delay. Even now, this is a half-baked cake. So what would you like to do?
Actually, Lordship, in the region of Twinsa, when the claimant has preferred the MSC case, there was no penal counsel over there.
Could be. They received notice.
They received notice.
Penal counsel is something for the company to
Representation.
look into.
Yes.
They could have engaged anyone and everyone. You have a panel, it's good enough. You don't have a panel, you engage anyone and everyone. So that delay, the court not being satisfied and not explained properly, even in this petition, it is not being explained properly.
Lordship,
So what happened from 2023 to 2025?
Lordship, in that eventuality, if I may beg your indulgence to file an affidavit, additional
Explaining from 23
yes,
to 25.
yes, Lordship, with the Lordship's leave.
Learned Counsel, you take it like this. This is an application filed for condonation of a delay of 761 days. See, again you will have to, I don't know, come to page 2, page 1. An application under section 5 of the Indian Limitation Act 1963. Do you have it?
No.
Please read it. Praying for
condonation of delay of 761 days
in
filing the above referred MSc appeal.
MSc appeal is already the condonation was refused. The MSc appeal does not exist on file as of today.
Yes.
So the delay should have been of condonation of
Aye.
in filing the application for restoration. What do you want to do? Either I dismiss it
Lordship, a chance may be
or
given.
you withdraw it to file an appropriate application
Lordship.
to correct the nomenclature.
Lordship.
Is it not? Because otherwise this will go Monday. No use keeping it pending. Okay. Heard Mr.
Vikramjit Devnath.
Vikramjit Devnath, Learned Counsel appearing for the applicants in IA 150 of 2025. On a pointed query to the Learned Counsel as to the on a pointed query to the Learned Counsel for the petition applicant, he submits that the delay of 761 days is not in preferring the MSc appeal, but in filing an application for restoration of the MSc appeal number 15 of 2025.
No, Lordship.
Restoration of the application praying for condonation of delay in filing the original MSc appeal. Okay? What does your prayer say? You have asked for. The prayer clause also does not refer to the restoration of the IA seeking condonation of delay in preferring the MSc appeal. When counsel seeks to withdraw the present interlocutory application with liberty to file appropriate application seeking condonation of delay in preferring the application for restoring the condonation petition filed in the application praying for condonation of delay in filing the MSc appeal. Prayer allowed. IA, what is the IA number here? 150 of 2025 is closed on withdrawal with liberty as prayed for.
For motion, item number 19.
What is this IA 151? Just in the other earlier case.
Lordship, that is stay.
Stay. Yes. Same problem.
Lordship, similar order may be passed, Lordship.
You repeat the earlier order. Here the delay, the condonation of delay of 289 days. In the earlier case it was 700 something. Here it will be 289 days. The rest will be the same. Yes. Next.
For admission, item number 3.
May I please, Your Lordship, I'm appearing virtually. I appear on behalf of Mr. G. Sahaiwala, who is leading me in this case, Lordship.
Yes.
Only difficulty is he is not available today, Lordship. So we pray for adjournment and we pray it may be fixed on 2nd week of September with a date. Also, my name may be shown correctly in the cause list. That will be a prayer, Lordship. I've made a prayer before, but it was not corrected. It shows in G Deka. It is D Deka.
What is in a name?
It's in the cause list, it shows as G Deka.
G Deka.
It should be D Deka. So any date on second week of September, maybe 11th, 17th.
Yes, PP sir. Any objections? Mr. D. Deka, Learned Counsel, appears
For the petitioner.
on behalf for the petitioner and submits that the leading counsel is indisposed today and could not appear. He seeks for an accommodation for the matter to be listed after 3 weeks. Shri so-and-so, Mr. Learned Public Prosecutor, does not object to the prayer made. List this matter on 9th.
Lordship, he has paid for 11th or 15th, Lordship, if it's possible.
Is it okay? 11th is 11th of September 2025. Full stop. It is also submitted. The cause list reflects the name of the Learned Counsel for the petitioner as within inverted commas likhega G Deka. He prays for a correction so that it reflects as D for Delhi, D Deka. Registry to verify the wakalatnama and correct accordingly. List on 11th of September 2025.
Highly obliged, Lordship. Interim order may be extended, yes, Lordship.
I have to ask it. You don't want it. Huh? No.
It was a motion.
Sorry.
The interim,
There is a problem.
there is no extension in between, Lordship, because we missed to appear. Lordship, it may be fixed on 11.
You file an application for
Lordship, they have not taken any action. We'll take steps, Lordship. Highly obliged.
This was item number
3.
3.
11, 9.
For admission, item numbers 5 and 6.
5 and 6, yes.
Maps, my lord.
Yes.
I'm for the claimant. I'm led by Mr. N. Mitch. He's not keeping well, so the matter can come up on 19th as the statute. Next Tuesday.
This is an IA for what?
IA is filed by the...
IA is filed for what, sir?
By the respondent 2 and 3.
For what?
My lord, here my IA is for bringing on record additional evidence.
In the appeal?
Yes.
You are appealing for?
I'm appealing for the appellants, Your Worship.
Appellants?
Yes, sir.
Have you filed your objections to
Yes,
this?
Your Worship. Your Worship, it can be fixed on the 19th and this matter can be heard entirely on that day.
A joint prayer made by the Learned Counsel for the parties. List this matter on 19th. 19th of
Tuesday.
August for further consideration.
For admission, item number 8.
May I please, my lord?
Yes.
Lordship, today the matter is I'm supposed to state is supposed to
obtain the updated case diary.
Yes.
Yes.
And after to hear the interim. However, Lordship, the IO of the case, he is recovering for a surgery. So he asked me to seek.
When did he undergo the surgery?
I did not
see. The difficulty is this. from 21/7,
Yes,
the interim prayer will be considered
yes,
on perusal of the case diary.
yes,
5/8, you received the case diary, it was not updated.
yes,
Fixed on 12/8.
yes, yes.
Now, when did he undergo the surgery? That is what I am asking you.
Even before, I think before the case diary was produced. So he was actually
Someone?
and besides that, not only that, they are trying to even file the charge sheet. So
Charge sheet filed?
No, they want to file the charge sheet also. So he requested me to pray for 10 days time, Lordship. So if that can be granted, if not otherwise also, this is not.
Because he is undergoing a surgery, do we understand that he will not be able to pursue the petitioners and
Yes, he's struggling. What is we've been pressing is just attending this case, I'm told. Otherwise, even otherwise, there's not the right.
Are you in immediate threat?
Not it.
Are you under arrest? No.
No, not under
You've
arrest.
not been
I'm
arrested
under
now.
bail. I'm under bail.
You are not on bail on this matter. Are you on bail on this matter? You are not on bail on this matter. In other matters, you are on bail.
In this matter.
When was it granted?
Lord, I also enclosed the copy of the order.
Then what is the interim? What is the interim you are praying for?
For staying of the FIR, which in view of the law laid down in the Niharika case, this honorable court may not interfere.
No. Why stay the FIR? We hear it, we finish it.
Yes, so my prayer is if 10 days time may be granted.
So you are on bail, you are not on immediate threat. We give him 10 days time.
I have received call just 2 days back, summoning me. And
something is not matching up. Either he is in the hospital or this is a ploy to get time.
This is simple, but again very sensitive lottery matter, connected lottery matter. So
I understand everything, but if your submission is that the person has undergone a surgery and therefore the case diary is not here.
Yes. No, case diary is here.
The updated case diary.
Yeah.
And I have been receiving
I
calls.
don't think he should be making calls. How would he be making calls if he is undergoing surgery?
Who calls? Who made the call? They also have.
It is only the IO of the case who calls.
Right,
Lord, you may kindly appreciate just
not
one
10
aspect.
days. Yes.
Just one. Page 42, if, sorry, trouble, Lordship. Page 42, this is the order passed by the Learned District and Session Judge. This is the order that has granted interim bail. It has also stated 2 different occasions where I was summoned. Paragraph.
It is with regard to the same FIR?
Yes.
So
Same
you are on
affair.
bail, why are you afraid?
And
Even if
another
you are
aspect, Lordship, another aspect, the law is very clear with regard to multiple FIRs. 3 FIRs are lodged. 2 in the state of West Bengal, Lordship.
This is
and
not agree for multiple. In the present
Lordship,
case,
I
they are
kindly
not agreed
appreciate
by
the third FIR, which was registered in the year 2023. Charges is already filed. Same allegation, Lordship. This happens to be the second FIR.
What I am saying is,
So, I was discharged from the case, Lordship.
you are on bail.
I'm on bail.
Let him have the updated CD. We don't give him 10, you are asking for 10 days.
Lordship, only 10 days.
Otherwise, without the CD also, the law is very clear. Multiple FIRs. On the same allegation, they cannot be more than one
You want
FIR.
a disposal today?
No, interim, I'm
Their prayer is not against multiple FIR, Lordship.
There is a judicial order which says that interim, okay. Accordingly, list the matter on so and so on which date the learned PP shall obtain the updated case diary.
Yes.
And the interim prayer
Yes,
will
that
be
is true, that is
considered
true.
on the same.
Yes, that is true.
Date.
But that is the circumstance. Even this one, the CD, he just furnished it. This IO. So he prayed. What he prayed was asked me to pray for 10 days. I mean that charge sheet also they make an effort to file the charge sheet also.
See, we are not inclined actually to stay an investigation when the updated CD has been called. I'm telling you the mind of the Lord. But we are also not inclined to grant you time unlimited.
No. Not, last time, Lordship, last chance.
Lordship, FIR was lodged in the month of March 2023.
I understand.
More than 2 years now.
I understand. They are still going after the updated CD.
Nothing has been recovered from my possession.
No,
We'll record all this.
No,
We'll record all this in the order.
There's at least there are 4 witnesses directly give their statement against.
See, the
There's
allegation,
something-
as I understood, was
Yes.
not that they are running a lottery show.
Lordship.
The allegation is that they are printing duplicate tickets and running a lottery show.
Lordship.
That is the allegation against you.
Yes, Lordship.
How long did it
And which has been taken care of in the third FIR.
take down? Hard Mr. Muajamil, you are
Lordship.
M. Jamil. Muajamil and counsel for the petitioners. By order dated 5/8/2025, this court had recorded that the learned public prosecutor shall obtain the updated case diary and the interim prayer will be considered on the will be considered. Earlier on 21/7/2025, the learned PP had submitted that he had received the case diary but it had not been updated. Next para. Today, this court is informed that the investigating officer is undergoing some medical treatment and therefore the updated case diary could not be made available. We are also informed that the petitioner has been granted the privilege of pre-arrest bail by an order dated 29/4/2024 by the learned principal district and session judge Kohima, Nagaland. Next paragraph. At the insistence of the learned PP, we are granting one last opportunity to furnish the updated case diary for consideration. Stop. List the matter on. Yes, Mr. PP.
Next week, Lordship, next week.
10 days ends only on Friday next. So the next following Monday or
25?
If it's possible, Lordship, can you accommodate next week, Thursday?
No, Lordship, I need the last chance, so 10 days at least, to be honest.
25th, you have it on 25th. Because I'm recording, this is the last chance. I've recorded that in the order. Is it not? You are on bail. I'll make an observation that you made a submission that there have been calls from the person who is supposed to be undergoing medical treatment. I will not say anything further, but I'll keep that on record that you made a submission. Will that do?
No.
Please the matter again on 25/8/2025 for further consideration of the interim prayer. At this stage, the learned counsel for the petitioner has submitted that he has been receiving calls to appear.
Yes,
to what?
Before the IO.
To appear before the IO in the matter. Without commenting further, place this matter on 25/8/2025. See, you also have to participate to some extent in the investigation, otherwise the updated case diary is not coming without your participation.
Lordship, whether will it be proper to record where I also making endeavor to submit the charge sheet in the meantime.
Okay. Learned PP submits that an endeavor is being made to submit the charge sheet in the matter at an early date. These two sentences will be together. That he's saying that there is a telephone call, and learned people saying that they are endeavoring to submit the charge sheet. Without commenting further on the same, will come last. Okay?
If the charge sheet is to be filed, it can be prior to 25th.
That will create a problem for you, yes. If you record the charge sheet part, then what happens? This interim goes. Because he's paying for the staying of the investigation. Is it not? Then again, the same problem as item number 1. Amendment of the prayers in the petition will come up. We'll see on 25th. We'll see on 25th. If you need to,
For orders, item number 9.
Contempt.
May I please, Lordship?
Yes.
My Lord, on behalf of the petitioners, as per this court's order, they have taken steps on respondent number 10, 11, and 12, and the steps taken on those respondents are still awaited. So if this matter can be listed after 2 weeks again.
List the matter after, heard Mr.
Takakicho on behalf of Takamasa.
Appearing for the petitioners who submit that notices
on
that
respondent
return service reports on respondent number 10, 11 and 12 are awaited. Accordingly, list the matter after 2 weeks. So and so appears for the, you are appearing for the respondent number?
1, my lord.
Appears for the respondent number 1. What happened to the other respondents?
Lordship, the other respondent 2 and 3 is represented by additional AG V. Shokri. She is on her legs at court number 1, my lord.
And you take her attendance. And others? Any other? Others are not appearing. List after 2 weeks. Said that, not?
Oblige, my Lord.
Oblige, my lord.
For orders, item number 10.
Yes, sir.
May I please, Your Lordship? Lordship, the petitioner has filed this contempt petition as the respondents have failed to abide by the order of this Honorable Court dated 01/07/2024.
Yes.
And on the last occasion, they have stated that they will abide by the order within 2 weeks.
Yes, where is Mr. N. Muzoi or anyone appearing for the respondents?
Until they have not abided by the order. It's already 1 year, Your Honor.
Who is appearing for the respondents, sir?
And Moji,
For all the respondents?
yes, my lord.
Where is he? What was the direction? Can we have the direction? What was the direction of the court?
The direction was for the state to release the salary of the petitioner from 1st April 2022 to 31st March 2023 within a period of 3 months.
When did you file it? 15/5. When did you serve the copy? They filed their wakalatnama. Someone appeared, or is it the government advocate appearing?
They have appeared on the last question, my lord, on the last date.
Yes, sir. Where is their? They filed any appearance, memo of appearance or wakalatnama? Anything? Who appears? How many more matters left? Sir, how many more matters left? One more matter. We'll have it after some time. Let us see if he comes. Pass on for the time being. Next.
For orders from the supplementary cost list, item numbers 20 and 21.
Yes. Yes, Mr. Devnath.
May I please, Your Lordship? Lordship, this is an application concerning the delay in preferring the restoration petition, my lord. Lordship, I have discussed at paragraph number 5, internal page number 5 of the application, Lordship.
Where is the order dismissing it? What did you dismiss it as?
Lordship, annexure 1 to the IE.
Is the company really interested in pursuing the appeal, or
Lordship.
is it just to delay the
No, no, Lordship.
delay succor to the
No, Lordship.
claimants?
The applicant company is interested, Lordship.
How come?
Lordship, as it was.
312. Kindly read kindly read page 12 of your IE. Says by order dated so and so. Please read the third paragraph. By order dated.
By order dated so and so, this court on perusal of the application indicated that the grounds contained in the application, more particularly the contents of paragraph 7, is not satisfactory. Accordingly, applicant was granted time to file additional affidavit providing opportunity for improvement. However, the application has not been improved till date.
It is not improved, it is filed. It should have been filed, but it's improved.
No, Lordship, it was filed, Lordship. It was filed, it was in the file, Lordship. But due to some inadvertent mistake, Lordship.
When did you file it? You
Lordship.
have that? Yes. Can I have IA Civil 210? Disposed of, I think. IA Civil 210. Is it there? It is not there. How it isn't? On the contrary, the applicant kept taking adjournment and remains absent on 24/105.
No, Lordship, it was filed before passing the order, Lordship. Lordship, I have filed on 22/1/2025, Lordship.
Okay, then you took a certified copy of this on 16/5/2025.
Lordship.
So how will we explain 24/1 and so this kind of delay? I find it difficult to even. Yes, madam, you want to file your objections?
No.
You don't want to file objections?
No.
You want the delay to be condoned? Appeal again to start. You are appealing for whom?
Respondent 1 and 2.
For the claimant respondents.
So they are challenging the award which is in your favor. And you don't want to file an objection to the. You take your instructions and come back. I don't know.
Lordship, otherwise also, Lordship, the claim was filed under 163A. But the compensation was passed as per 166. If your Lordship may peruse the judgment and order. It ought to have been as per the second schedule.
What is this IA? IA 90? I'm looking at IA 90. What is IA 90?
IA 90 is the delay, Lordship.
Then what is this we are looking at? 91?
91 is the restoration. Sorry, 91 is the delay, 90 is the restoration, Lordship. It should have been 90, the application 90 should have been delayed.
So, but notice has been issued on the. This did not come to notice or what? Why am I not understanding it? What is your prayer here? (28/105). You filed this on. When did you file this? Date of filing 18/6. When was this IA 210 of 2024? What is that?
210 of 2024 is the additional affidavit I was asked to file, Lordship. That was on record.
No, you filed an IA for condoning the delay in preferring the MSc.
Main appeal, yes.
Yes, that was IA number 210 of 2024.
Lordship.
Are you sure?
Yes.
So that was dismissed on 28/1/2025.
2025.
and you filed this IA 90 of 2025 for recalling the order dated
28/1/2025.
28/1/2025, but there was a delay.
Lordship.
Now, without considering the delay, there is an order here which says that notice has been issued on the
Respondent number 3.
1, 2, and 3 without condoning the delay.
No, respondent 1, 2 appeared, Lordship, since the last 2 dates.
No, you took steps, maybe they appeared. I'm not on that.
Yes. Only respondent number 3, the owner.
I'm not on that. What I am asking you is,
Lordship.
there was a delay in filing this restoration petition.
Lordship.
The delay has not been condoned.
Lordship.
And how notice was issued on the IA for restoration? लिखिए. You will take this down in IA Civil 91 of 2025. ठीक है? In IA Civil 91 of 2025. This interlocutory application has been. एक second. Oh, there is an order here. There is one order here. Service upon respondent number 3 may be awaited further. What happened to it? Address is not found.
Lordship, but this is the same address which has been in the claim petition as well as the judgment and order. As per that address only, I have taken the steps upon respondent number 3.
Dikleshwar Karmakar. You make a verification once through your, if you need to give an updated address or something.
Lordship. But it will be the same address, Lordship. Even in the
No, then we'll have to go to some other process. You'll have to go for paper
paper
publication.
publication. There is a last resort.
So before that, do you want to take an opportunity to find out?
Okay.
Because address is not found. Return to sender. Address is not found may lead to complications on your part if you can show that. Or strike out whatever you did. Office note dated 11/8/2025 reflects that notice to respondent number 3 has been returned with the remark addressee is not found, return to sender. Learned counsel for the applicant prays for a short time to take instructions on the status of respondent number 3 and his address. Full stop. List the matter on 26th of August. You try to just find out whether
Lordship,
that
very short date may be given, Lordship, because the practical problem is they have also filed one execution in the trial court.
you came to this court because there is an
Yes.
execution filed.
Yes, yes.
You did not come because there was an order of
No, previously
Order
I came
awarding the
before,
game.
against the judgment and order.
Yes.
Lordship, I will take the instruction within 2-3 days, Lordship, if it can be listed on this week.
list this week itself.
Lordship.
We list it on 18th. 18th, Monday.
Lordship.
Today is Tuesday, okay. List again on 14th.
Lordship.
14th is fine.
Lordship.
List again on 14th. 14/8/2025.
Obliged.
If that address is not found, we'll go for a paper publication or something, whatever we want to do.
For
Yes.
orders, item number 10.
10. Yes, madam.
May I please, Your Lordship? I'm appearing on behalf of Mr. M. Mujoy, the standing counsel for respondent number 1, 2, and 3.
Yes.
He's indisposed, so he's not able to present today. However, I'm communicated that the matter has been approved already. So 2 weeks' time may be granted. That's the
Only
submission.
payments to the petitioner are left and the same will be done within a short period of time. That was on 23/7/2025. 23/7/2025 is long gone.
Lordship, Lordship.
So what we do is we fix this matter on 21st.
Lordship, Lordship.
21st of August 2025.
Lordship, Lordship. So that the council may be allowed to place on record the proper documents now.
On a prayer made by on a prayer made on behalf of the Learned Council for the respondents, list this matter again on 21/8/2025, by which time the updated the compliance report will be submitted to the court. Since on 23/7/2025, a statement was made that directions for compliance has been adhered to and only payments to the petitioner are left. On failure to comply by the next date fixed, appropriate orders would follow.
Obliged, Lordship.
List on 21.
Obliged, Lordship.
For hearing, item number 12.
Only 12 left. Yes, what is this?
Yes, my lord. My lord, this is a quashing petition, but I would like to give a brief background about this matter. This is a central project authored by the Union of India. In 2010, the work has been awarded to me. So in 2011, a contract was signed between the state of Nagaland and Maitas Gayatri joint venture. It's a joint venture. I'm for joint venture here. My lord, in the contractual world, there is one called bill of quantity, where I will execute the work, then I'll raise the bill will be paid. Now, with the new government or the present government to say, the contractual parallel has been changed. Now it has been EPC mode, where the government will sanction the lump sum amount, and within that amount, within that jurisdiction of that amount has been sanctioned by the government, I will execute. But this is a matter of BOQ, bill of quantity, will execute the work, and then the amount will be sanctioned accordingly.
Okay.
So now, Lord, my Lord, before I come to this present matter, I would like to give a brief picture about the background. So here now, my Lord, the project consists of 4 lanes. This is a central project. The central government wants to upgrade in the state of Nagaland in some stretches consisting of 329 kilometers from 1 lane to 2 lane. So now there are 4 lanes. One is before here, where the matter has been sublet to one Ratna Infrastructure Private Limited, which is also based in Hyderabad. But this company is not before this court, so I will not make any allegation against that. Now, in other 3 stretches, they have no issue, but this stretches has some issue. The respondent number 2, so-called, filed 2 matters. One is criminal case of 2018 before the Longland CGM court. Simultaneously, there is a civil suit of money suit of 2018, which have been filed simultaneously, deal by the same CGM. So here in short, if at all, the matter is if there is a dispute in the matter, it will of civil nature because it's of contractual obligation. Criminal matter, I cannot be roped in, and then even the vicarious liability cannot be in all these hidden matters. How can I be a lead in all this vicarious liability? My Lord,
where is that complaint case? Can I have a look at the complaint case?
Before coming to the complaint case, my Lord, I want to give some of the background. In the year somewhere in 2013, this is a project of 2010. 2011 agreement has been executed. The a person from Nagaland, a public spirited person named Hitobi Kapo, he has instituted a PIL for execution of the work because there are some delays. Because there are some misunderstanding between the Maitas Gayatri and then the Union of India because of certain cost escalation, my lord. Because the DPR has been in default by itself. So therefore this has been, before this, the Honorable Gauhati High Court, the matter reached Supreme Court. In 2017.
What I'm trying to understand is this.
Yes, my
Your
lord.
basic contention is
Yes.
that the criminal proceedings
Yes.
instituted by way of a complaint
Yes, my lord.
and a suit should not proceed at the same time. Is that what you're trying to emphasize?
My
That
lord,
is one of the points.
Yes, that is one of the points.
The other
When-
things, I've just gone through your synopsis.
Yes.
Other thing says that because the accused are residing out of the territorial jurisdiction,
Correct.
then certain procedures should have been followed.
Correct.
Right. Then you
Yes.
are saying that before issuing summons, no inquiry was held and all that.
Correct.
To come to an understanding as to whether the complaint case and the civil suit,
Yes.
they both go into the same territory, they do overlap each other or not.
Same issue.
First thing that I have to see is what is the complaint about.
Yes.
The second thing that I have to understand is what is the suit for.
Correct.
So therefore, I was requesting you to show me
Correct. I will.
the complaint case.
Correct, my lord.
Because other background we will go to. You are also prepared, we'll hear this matter, or are you taking time on the matter? Okay.
Lordship, if I may.
There is no affidavit in opposition. They said like they'll not file it. Then they'll go ahead with the argument. Yes.
If we find enough grounds, if we find enough grounds, we may go with you.
Lordship, if I may, civil suit is not before the CGM.
Cannot be.
It is with the civil judge, senior division. So
Maybe the same person handling both the
maybe
offices,
some, but the different designation is there.
understand.
Yes.
So now just show me the complaint. Where is
Yes,
it?
my lord. Yes, my lord.
Where is it?
Yes, my lord. My lord, this
Page
paper book
21?
compilation, you are with the paper book compilation?
yes,
part
page
one, part
21.
two? Yes. My lord, page 88.
Huh?
Page 88.
88.
Page 88. Type copy.
What is this, page 22?
Page 22, my lord.
Page 88, are we on the same book?
Yes, yes, my lord.
Here, page 88 is some bank guarantee by ICICI Limited.
Page 40. No, my lord, this complaint, this is a compilation if it is written 88. 088. I'm referring to this same, maybe, please cross check it.
38, your lordship.
You are on paper book, part 1 or part 2?
Part 1.
Part 1, page 38. This is the complaint.
What is 22? According to you, what is 22? Can you just see? Again, my page 38 is a different thing. It is Maita's Gayatri rights to improvement of road. That is what you are talking about. Let me see his copy. Can you send me a copy?
Yes, yes, yes. Even page 38, this is a criminal case. Yes, but I'm sorry, I want to go to the complaint. I'll want to take directly to the complaint.
Yes. Okay, the sealed one is the page number. I was on the circle part. Thank you.
Sir.
Okay, page 40. Yes.
Yes.
Bonafide citizen of India is a permission insurance company is a registered company to the party is a private company. Its main office. We are reading page 40.
Yes.
Is who is the complainant? Okay.
This is the criminal case. But if my lord go to page 88,
Just a minute, sir.
Yes, ma'am. This is the second time I'm coming before this honorable court. In fact, I have my company gone insolvent now, my lord, because of this particular matter. This matter is led by one senior advocate, Mr. Anand Kumar, whom I've not been able to engage because I'm bankrupt today. There is a proceeding happening before the NCLD in Hyderabad, my lord. All my properties has been seized, my account, everything has been seized. But in short,
No, what does the complaint say?
the complaint is saying, my lord, there were 2 work orders issued by this Maitas Gayatri so-called, which I'm saying like,
Yes.
which I'm saying, the petition number 1 to 4, it's nowhere saying like, I'm privy to the contract or the work order, or nor the sublet work has been privy to the main contract agreement, which I'll take you, my lord. It is signed by Mr. Y.L. Ambernath, who is not my authorized employee or authorized representative. So all these work orders, all these complaints are aligned to me, my lord.
And where is the suit? The suit is here?
Yes, the suit is in 2, my lord, part 2, my lord. And both the criminal case and then the so-called the legal notice or the money suit, these are all inconsistent with it, which means that it is a fabricated, concorded, manufactured, my lord. It's nothing else. They cannot prohibit me in using this criminal jurisdiction proceeding, my lord. If at all, if a dispute arises, it will be it will be of civil dispute. My lord have page 476 in part 2, money suit number 1 of 2018. He has enclosed all the work letters, everything, whatever is enclosed in the criminal case is also enclosed in the money suit. But the amount in criminal case, they are saying like 3 crores something 9 lakhs. But here in money suit, they are again 2 crores 84 lakhs, 44,000 so and so.
Your good name, sir?
Michael.
Michael.
Yes, my lord.
Now, we will not go into the evidence part.
Yes, my lord.
Or the other part of it at this moment.
Yes.
We'll
Forget
just
about
try to find out that whether any of your grounds taken in this revision
Yes.
deserves consideration.
Correct, my lord. I have some supporting judgment which I'll place before your court.
So now tell me your grounds first. What are the grounds you'll be arguing on?
Yes.
Sir, you may take your seat. We'll take some time. You can sit down. Yes.
Lordship, sorry.
Take a seat. It'll be easy. Yes, your grounds.
Yes. So, my lord, the CGA here, before that, I would like to give some brief background, my lord, so that at least you know the background and the situation as such before coming to all these kind of issues. Forget about the essential ingredient. Even the allegation doesn't found anything against me, actually, my lord. So, therefore, I want to give the brief background so that your lordship understand the entire scenario, how the things have come to the picture. My lord, now I was saying like in 2017, the matter has been foreclosed by Honorable Supreme Court as far as all these stretches are concerned.
Where is the order?
So the order is annexed in my annexure A3, page number, it will be in part 2 to 428.
Part 2?
Yes.
Page number?
428.
428. Let us see. Yes.
Yes, my lord. Now, a public interest litigation, I'm reading para 2, my lord. A public interest litigation was filed in the Gauhati High Court invoking the jurisdiction of High Court under Article so-and-so of the Constitution of India. The petitioner had invoked the jurisdiction of the High Court in an effort to expedite the laying of 329 kilometers road, the construction whereof had been stalled. So this is the basic issue, followed by the prayer, nasas, and so on, so my lord. Now, my lord, might come to page number 431, para number 5. My lord, have that?
Number 5.
Yes, my lord.
Yes.
In response to this is by the Supreme Court asking for certain queries before the Union of India, because Union of India went on to challenge the division bench order of the Gauhati High Court, where the Honorable Gauhati High Court has passed certain direction to pay some amount which the contractors have worked. So the Union of India has agreed by that, so therefore they went to challenge before the Honorable Supreme Court. So in response to the direction queries extracted here and above, a report dated so-and-so had indeed been filed before this court by the superintending engineer Moore. The same has been placed on the record of this case by way of an additional affidavit. It is essential for us to extract herein paragraph 23 of the aforesaid additional affidavit. Insofar as direction 5 is concerned, I respectfully state that and submit that vide minutes dated 11th of August 2015, the petitioner, that is Union of India, has already concluded that contractors, which is Maitas Gayatri, now the petitioner before this honorable court, and PWD Nagaland, which is one number 1, have not observed due diligence in carrying out the works in accordance with the sanction granted by the petitioner, that is Union of India, and subsequent instruction dated so-and-so, and has accordingly decided to foreclose the contract.
Here Maitri was respondent number what?
Maitas Gayatri was respondent number 7, I suppose, before the Honorable Supreme Court.
We don't go by guesswork. Ask someone to confirm. Yes. Page 429, para 3, last 4 lines. Yes.
Yes, yes, my lord. So, my lord, now, this paragraph shows that, now I'm reading 432, my lord. A perusal of paragraph 23 extracted above revealed that the appellant herein had already decided to foreclose the contract. It is also apparent that the appellant herein had already decided to execute the above mentioned project by inviting fresh tender, my lord. So now, coming back again to para 7 of page 433, my lord. Having heard learned counsel for the rival parties, we are satisfied that the public interest litigation initiated by respondent number 1, that is Itobi Kapo, who is the petitioner before the Honorable Gauhati High Court, was with the sole object of having the road project completed at the earliest, pendency of the present proceeding before this court.
Yes, we have seen the order of the Supreme
Yes, my lord.
Court.
So, yes, my lord. Now, my lord, I want to take you to my Annex 2 of the contract agreement, my lord.
That is a page?
That is page from 79. Yes. Some page, where is the contract agreement?
So what do you want to say on this Supreme Court order? Why did we read it? What is your submission on this?
No, my lord.
To say that?
Yes, to say that we are joint ventures, but the allegation here by the respondent number 2 is only against the Gayatri. This is a joint venture project. A project before even executing the contract, Maitas and Gayatri as a joint venture has taken off the work. We are executing the work, and this project has been sublet to Ratna Infrastructure Private Limited, who is not here before this honorable court, so I will not say anything about him. So, my lord, now why L. Ambernath, who has signed the 2 work orders issued to respondent number 2, is not.
We are again going into the facts and evidence that you would be relying upon either in the criminal petition or in the suit?
Yes, my lord.
We are not on that. Tell us why the criminal petition should be allowed in law. When we are exercising revisionary powers,
Correct, my lord.
we would not like to entertain any argument on what is the evidence, how should we appreciate the evidence and all.
Correct.
That. What we would like to see is this part of the law has not been followed.
Yes.
Therefore, this is wrong.
Correct.
This procedure has not been followed.
Yes.
Therefore, this is wrong.
Correct, my lord.
This is overlapping or
Yes.
against the settled law.
Yes.
Therefore, the revision should be allowed.
Correct, my lord.
Yes,
It-
Lord.
The revisionary power of this court is very limited.
Yes. But it has an inherent power.
It has the inherent power to do it when?
Yes, my lord.
When we see that it will be a case of injustice.
My lord.
Now, to show injustice, you don't need to show us the evidence.
Correct, my lord.
You have to show us that even allowing the investigating authority or the trial court to proceed
Correct.
in itself is injustice.
Yes, yes, my lord. My lord.
For that,
Correct.
we don't have to wait for the evidence to come on record.
Correct, my lord. I appreciate. I'm in
Either you have
agreement.
to show me that the procedure laid down by law has not been adhered to,
Yes.
or it is a case where nothing is really revealed from any of the allegation or the FIR or the complaint or whatever. Nothing, no offense is even revealed.
Yes.
Even if we take it on the face of it, there is no offense.
Yes, my lord.
In that case, we will like to interfere.
No, my lord.
But if we try to connect this evidence with that and that statement or this action, I think we are going into trial. I will not go into trial.
My
I'll
lord,
be very clear on that.
That's why I'm not coming
So-
to the matter. Actually, there
so
is a
let us do
brief
it this way.
background. The genesis should be. So
No,
I'm
genesis-
just, yes, I'm just putting
Well,
forward to my lordship.
from what I have understood is,
Yes.
there was a company which was under a contract with the government of India.
Yes.
The contract was not being executed as it should have been.
Yes.
There was a PIL requiring to do the same. The Gauhati High Court said, pay them their dues, get the work done, this is urgent. Supreme Court interfered in the matter, saying that, look, this is not the job of a writ court. You want the project to be completed, give the respondents whatever leeway they want, retender, whatever they want to do, you complete your project.
Correct.
So far as the rights of the person who was already in contract with the government of India, liberty was granted to them to approach under arbitration or under any prevalent law which they can claim a right and have their issues adjudicated upon.
Yes.
In the meantime, another person comes up to say that Maitas Gayatri joint venture, I had entered into an agreement with them. I executed whatever works they wanted me to do. They have not paid me the money. So I have been asking them again and again. They have not paid me the money. So I institute a civil suit. I also institute a suit saying that they have cheated me with dishonest intention and all that. I filed a complaint.
Yes, there
Now
is
the
my
person
guess.
who is facing the who against whom cognizance has been taken, has cognizance been taken? Yes.
Yes.
Yes,
Already
where
has been
summons have been
taken,
issued and all
Lordship.
that. That person comes up before this court to say, look, sir, the magistrate should not have proceeded with the complaint petition in the manner in which he has.
Correct.
For that, you have referred to section 200 of the CRPC, 202 of the CRPC, and what else? Yes. Something more you have referred to, yes.
192.
Then you have
469.
192.
So your
of
allegation
CRPC,
is
469
Ha.
CRPC.
So your submissions are that these being not followed and the judgments or the law laid down by the Honorable Supreme Court in Vijay Dhanuka and other cases which you are seeing,
Yes.
this not being followed, the criminal proceedings should be interfered with.
Correct.
That is the reason why you got a stay on motion stage itself.
Correct.
So now we do not go into all the other details. We will try to keep our arguments short.
Correct.
You need some time for preparation. I am here this week, I am here the next week. We want submissions only on the law points. If required, to appreciate the law points, we will go into a little bit of the facts.
I'll finish it today, my lord. If my lord permits, I'll finish it today.
Start. That is what we are asking for. That is what we are asking for. See, we have got very little.
This is a matter of 2019, my lord.
We want it finished.
Yes, my lord.
So,
yes.
Let us go on that line.
Yes.
Let us go on a date-wise line.
Yes.
A timeline as to when what happened.
Yes.
Facts.
Yes.
No arguments. Then we say these are the points on which this criminal proceeding should be interfered.
Correct.
Baki, wherever we need to refer to any facts, anything, we'll definitely take your assistance. We'll find out what is the fact we need to.
Correct. Okay. Yes, ma'am.
So therefore, I was trying to see what is the complaint about.
Yes.
And the orders passed in that complaint. You have. Is that what it is? You are appearing for whom, sir?
Yes,
sir, you are appealing for?
I am for the
respondent number 2.
Respondent number 2 is Sandeep Kumar Reddy. No, you are Limakum.
Yes,
you are appealing for Limakum 4.
Yes, my lord, the complainant. Respondent number 2.
State has got
State
nothing
is
to.
the 1.
You are for the state. Number 1. Okay, now which is the order you are challenging? First, show me the order you are challenging.
Yes, ma'am.
If we allow the repetition, what goes? Summons dated 21/5/2015.
Yes, my lord.
Annexure
My lord,
1 series.
come to page number 37. Annexure 1, page number 37 of paper book 1.
37. Yes.
Yes, my lord.
Yes.
This is in the court of CGM so-and-so, Longland, dated 21st of May 2019, my lord. The witnesses in connection with CR 118 present with complainant, all the witnesses were examined on oath and their statement has been recorded, issued summon to the accused. This is in short, my lord. So now, what are the statements of the witnesses or what are the statement of the complainant, my lord? Page 81, my lord, type copy of part 1.
Yes.
Statement of the complainant, namely Lima Kumpom, son of so-and-so, which was recorded today on 12th of April 2019. Oath administered under so-and-so. My name is so-and-so. I am a permanent resident of so-and-so. By profession, I'm a first-class contractor, registered having so-and-so. My lord, this is very important, first-class contractor, my lord, because I'll be referring to the work orders subsequently, my lord. Now, I have filed a complaint against Gayatri, only Gayatri, my lord. This is a joint venture, Maitas Gayatri, but they choose only me, which I have not knowledge about who this person is also, my lord. Subsequently, I'll come to that. So now, Mr.
Filed by Maitas Gayatri, joint venture.
Yes, but he chose only to put an allegation against Gayatri only, my lord.
Okay.
Yes. So Sanjeev Reddy, who is also from Gayatri, Mr. G.V. Rao, who is also from Gayatri, then Y.L. Ambarnath, who is not my employed, who is neither my authorized representative, my lord. And A.S. Vinod, who is also an employed of the Gayatri, my lord. So, except Y.L. Ambarnath, 1, 2, 3, and 5 is before this honorable court, my lord. So sometimes in the month of March, April 2015, I was issued 2 work orders, so-and-so, dated 5th of March 2015, and second work order dated 2nd of April 2015, amounting to 7,62,76,000 so-and-so, and 35 crores 19,77,000 so-and-so. Subsequently, I commenced the work as per the work order. As the contract been supplied to me, and also as the contract work was executing in my native village, Longland, Changtongnia, I put all my efforts to accomplish the said supplied contract. Subsequently, in the month of July, I submitted my first bill amounting to 64 lakhs so-and-so. However, I was not released any amount. Mr. Vinod Kumar, who is the petitioner number 4 here before this honorable court, also known as engineer in charge of the said project, assured me to clear my running bills within 45 days. However, he failed to do so. I was assured verbally on several occasions but never made the assurance. Later part, in the month of November 2015, the said company Gayatri deposited 25 lakhs to my account maintained in Vijaya Bank on 2nd of November 2015. After the deposit of 25 lakhs, I proceeded my work without fail. Thereafter, the said engineer in charge, Mr. A.S. Vinod Kumar, kept inspecting and updating my work. I was also introduced to Mr. Ambarnath Babu by Vinod Kumar, stating that they are both authorized signatory of Gayatri, that due to non-payment of pending bills and assurances that were provided to me by the said signatories, I felt immense financial hardship, and as a result, I could not proceed with my work. I also tried to communicate with the officials based in Hyderabad through intimidation, letters or legal notices, but there was no outcome response. So purportedly there were two legal notices which are also inconsistent of each other, and then one is undated. I could only contact Mr. Vinod Kumar through the telecommunication. No number has been given, but after some time he stated rejecting and ignoring my approaches. I tried every possible ways to claim my bills. However, they tried to deviate from the liabilities. That as a result, they have committed criminal offense against me, and also because of the illegality activities committed by them, I endured untold suffering mentally and financially. Therefore, I pray to this honorable court to award them benefiting punishment under section 406.
Whatever you are arguing now
Yes, my
may benefit Maitas Gayatri JV. You have three other petitioners.
Yes, my lord.
If I'm not wrong, they are TV Sandeep Kumar Reddy, GV Rao,
Yes.
Amanathan Babu.
Yes. No, Vinod Kumar. This Ambarnath Babu is the one who assigned the two work orders.
Okay, we leave out Amanat Babu. We come
Yes.
to Vinod Kumar.
So all the four are before this honorable
Till
court.
now, you are arguing that there was only a statement against Gayatri, and therefore Maita should not have come in.
No, my lord. This is a project between a joint venture executed by Maitas and Gayatri. Therefore, they singularly choose Gayatri, but we have no dealings.
When you say we, you are referring only to Maitas Gayatri joint venture.
Yes, and
this argument is not for the other three.
Yes, my lord. No, this Mr. Sandeep Reddy, who is also employed of Gayatri, Mr. the GV Rao, and then A.S. Vinod, all are my employee of the Gayatri, my lord.
So,
but I have no dealing with the respondent number 2, my lord.
No, Gayatri is not before us. Maitas Gayatri is before us.
Yes, my lord.
Gayatri joint venture is before us.
Yes.
Gayatri is not before us singularly.
Yes, my lord.
So, when you say that you have no dealings with while Amarnath Babu,
Yes,
who
my lord.
signed who allegedly signed the contract, or
Yes, my
anything,
lord.
and you are making a argument that Gayatri, the allegation was singularly against Gayatri.
Yes, my lord.
Therefore, Maitas Gayatri joint venture will not be held liable in this. The
Even-
court should not proceed against Maitas Gayatri. That is one part of your argument. Am I misunderstanding you, or is it correctly understood?
So, my lord, here.
Then does your argument not go against applicant number 2, 3, and 5? Because they are persons from Gayatri. Allegation is against Gayatri and the
Yes.
officials.
Yes, my lord. So now I'm saying like this respondent number 2, 3, and 4, petitioner 2, 3, and 4, I were for Gayatri, but I'm all of them. But my lord, what happened is, in this, I have no dealing with respondent number 2. What? That is all my contention is.
The dealing, whether you had dealing with or not, whether you had anything or not, is a matter of evidence which has to go to trial to be found out whether you were responsible for all this or not.
Yes.
Revision, again I am telling you, is a part where we either stop it because of procedural flaws or we stop it because there is grave injustice.
My lord, this is
We
a
will
grave
not go into
injustice
that
because this honorable court and then the honorable Supreme Court has time and again in a cabinet of judgment, there are a lot of judgment which I'll be placing before you, my lord.
Saying what? To what effect? Just give me a gist.
Yes, a person, and then there are two, 3 issues which I want to put forth, my lord. I have no dealing, number 1. Number 2 is we are from Hyderabad, Andhra Pradesh. So we are beyond the jurisdiction.
Come to that. That will help all of the applicants if I agree with you.
Yes,
but if you are
but
trying
I'm
to
coming
say-
point by point, my lord. My lord, I appreciate, my lord, is much ahead of me, but my lord, I want to put for point by point, my lord.
Okay.
Yes, my lord. Yes, my lord.
So your first argument, if I can just sum it up, is that the allegations were against a particular entity called Gayatri and the officers.
Yes.
Gayatri and officers
Who was not dealing with respondent number 2?
who do not deal with R2.
Yes.
And who dealt with R2? It was the...
It could be someone else, maybe because this matter has been sublet to...
Therefore, applicants are in no way involved. That is what you are trying to
Yes, my lord. Number 2 is, my lord, the issue number 2 is now, we are from, if at all the dispute arises, it should be of civil, but my lord, we are beyond the jurisdiction of the District Court of Nagaland, my lord, Longland. So, in this, I have some supporting judgment. A person who is beyond the jurisdiction, the learned trial court should pose, inquire either himself or direct someone, the police officer or someone whom he can authorize, or the lower of the concerned officers, to look into the matter, postpone the issue. If they find it, take cognizance. Nothing has been followed, my lord. Nothing has been followed. Yes.
CRPC. Can you show me that order dated 16/10/2018? If you come to page 11 of this paper book 1, page 11, para 3, you have referred to an order dated 16/10/2018. Can I have a look at that?
Yes, ma'am. My lord. Yes, ma'am. This is in my... My lord, unfortunately, that order was not here, but I'll put page 439 as annexed 4 of my paper book 2. I have challenged that, yes, but the order is not here. But yes, but the final order,
16/10/2018. What I read from the CRPC is this. Shall, in a case where the accused is residing at a place beyond the area in which he exercises jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation.
Yes.
So you are saying that without any application of mine on 16/10 he took cognizance.
Yes. So therefore I challenge. That was also criminal petition of 5/2018. But this honorable court, because the matter was led by the senior advocate, the junior counsel appeared, but the court said like, no, this is a short matter. I'll send it back. I'll quash the summon. I'll quash the order, and then I'll send it back. So followed by the order, my lord.
Okay.
The order is in Annex 5 of 8th of March 2019. My lord, have that page 469, my lord.
469.
469 of part 2, my lord.
Yes, yes. Try to press up. 469. Yes. Yes.
My lord, might go directly to page number 471, my lord. Para number 10.
It is between the same parties regarding the same
Yes,
complaint.
same party. Yes, my lord.
Same parties.
Yes, my lord.
And
That,
now
that is a
they
gone case, Your Honor.
In fact,
After that, they file again 2019,
Yes.
they'll file. So it's not
They are
necessary to.
seeking reappreciation of the evidence which has already been decided in the earlier petition. So instead of
My
wasting
lord,
God's time,
I'm satisfying my lord's query.
one at a time.
yes.
We'll go one at a time.
I'm satisfying my lord's query. There is nothing as such.
Actually, that has been decided.
Yes, that is decided.
It's a gone case. Now they come with another new petition, that is 5/2019. Now we are dealing with this, Your Lordship. It may not be much.
My lord,
need in this.
you might go directly to page 473, the relevant parts, para 15.
42. No. Relevant para is 473, yes. Para 15 and 16.
Para 16, yes.
Yes.
I'm assisting my lord.
Your Lordship, that has been done.
Yes, it has been complied with.
Complied with, and another new application has come, and that is 5/2019.
Now, after this 1610-2018, now after this order of this court remanding the matter back, what happened?
Yes, my lord.
See,
8319, after 8319,
yes, page 79, part 1, page 79, Your Lordship. May kindly have page 79.
Page 79?
8319 on 25.
Yes, there
All
is a
the
type.
orders are there, type copy.
And the relevant one
Now,
is at
now,
page
now,
80.
tell me one thing. How is this order dated 21/5/19 sustainable? Because it appears to be a repetition of 1610.
Correct, my lord, correct. Agreed.
That is what I was trying
Agreed.
to find out.
He has done nothing.
That is what I'm trying to find out. Please come to page 471.
Yes, my lord.
And then we come to page, where is your impugned order of 21/5?
Page number 37, my lord.
37. Let us see what has he done in between. Now, you tell me one thing, Mr. Michael.
Yes,
You are
ma'am.
saying that he did not cause an enquiry into the complaint before issuing the process.
Yes, my lord.
That is one of your arguments.
Yes, my lord.
What is the extent of the inquiry that the magistrate has to make? What kind of an inquiry the magistrate has to make?
My lord, he can order or direct the police officer.
No, that is already provided for.
Yes.
An investigation to be made by the police officer. It's an
Yes.
or.
Yes.
When we have an or, we say you can do this or you can do this.
Yes, my lord.
So, investigation by a police officer is one part of it.
Yes.
He can inquire into the case himself.
Yes.
What is
that
the
is the
extent
point,
of
Lordship.
inquiry that he has to make?
My lord,
How does he make that inquiry?
my lord, that the trial court at best should have recorded saying like I'm satisfied, therefore I'm taking cognizance, therefore as per so and so. Some reason has to be given with an application of mine. Nothing is there, my lord.
The order is there, Your Lordship.
It's just one paragraph, my lord.
Magistrate has satisfied. That's
Where
why
is
he
the
has taken
where is the
cognizance.
satisfaction order, my lord?
His order, let me show you, Your Honor. He is taking much time. You see,
We'll
page
decide your issues
79,
one by one.
Your Lordship.
Yes, my lord. Yes, yes.
Page 79, please, Your Lordship.
Page 70.
9. part 1. All the orders are here.
Now, when I have
You
no
see,
dealing,
12.
this is the allegation, my lord.
Wait,
I don't know who is respondent number 2
I
is.
say that I have dealing with you. You have assigned me, issue me 2 contract
Page
work.
79.
But that is the evidence part. If you are too innocent, why don't you just come to the trial and prove your innocency?
There is a law preventing.
That is why we are coming before this honorable court.
It is my petition, sir. It is not a petition, with due respect.
But we should not go outside the box.
If you have so much of grievances, if you have so much to say, you should have filed an affidavit in opposition, my lord.
My lord, it
In
is my
simple-
wish that I will give in oral submission. That is why I come before today. They cannot force me to file a affidavit.
I'm not forcing.
Yes, Lordship.
So this is how it happened.
Yes.
Yes, what were you saying? Tell us.
You see, Lordship, page 79, if I may take you, Lordship, see, order dated 12/4/2019, the last para has, you see, perused the criminal complaint filed by the complainant Shri Limagam, recorded the statement and the complainant on oath under section 200 CRPC. The court is satisfied after making an inquiry under section 202 of the CRPC, hence register a criminal petition under section 406, 417, 420 IPC. Issue summon to the accused. Satisfied. He has complied with.
Now
What grievances do they have?
Now kindly come to page 471 of paper book 2. Mr. Michael, you take your seat. I'm trying to understand
And Lordship,
to your satisfaction as to.
yes. May I just read one more order?
Yes.
The next page, page 80, 20.
Yes.
The witnesses in connection with CR 118 percent with complainant, all the witnesses were examined on oath and their statement has been recorded. Issue summon to the accused, fixing 13.
Yes.
So as a magistrate has taken all the steps
Now let
which
us
has been
come-
essential.
Now let us come
And
to
she is satisfied.
page 471 of paper book 2. We will just try to find out whether I'm not with you. I'm not.
But
Find
your
out.
lordship, without going through all those.
No, we'll only go through the orders. Don't.
Argument. Let me just give my brief, very short. I will take only.
He has not finished. I'm just trying to find out the other part. Can you come to page 471 of paper book 2?
Yes, 471.
Received. You see that order, paragraph 10.
The order that 16/10/2000
Yes.
passed by the court of CGM Longlang
Is
is
reproduced.
reproducible. Yes.
Then we read that order.
Yes.
Received a criminal
you see,
complaint.
Received criminal complaint. The complainant named Lilima Agam, which was filed through his representative, namely Ailima Doshi Bendamla Amkasa, before this court. The complainant stated that 2 works order issued to him by Maidas Kaitri joint venture on 5/3/2015 and 2/04/2015 respectively. However, on executing the work and on submitting the bills, no payment was released. I have perused the criminal record complaint and also the statement made by the complainant and satisfied. Registered the criminal complaint. Issued summon to the
Defendants. So now
Yeah,
in this
defendants.
case, in the earlier occasion, summons were issued on the basis of the complainant, a statement made by the complainant and on perusal of the criminal complaint. Am I correct?
Yeah, criminal complaint is.
Now if we come back to page 79, which you are saying is the order dated 12/4,
Yes.
the same thing has been done. See, recorded the statement of the complainant on oath and register a criminal complaint, petition, issue
Yes.
summon. Summons were issued. Very similar, both of them.
At the time,
Now on 21/5/2019, on the next date, he goes to examine. All the witnesses were examined under oath. So therefore, on 12/4/2019, no one except the complainant was examined. Is examining the complainant the only inquiry the magistrate has to make before issuing summons, or would the inquiry require a little more effort on his part? Is what I'm trying to understand.
Yes.
Is what I'm going to ask you.
Yes, Lordship.
Because order dated 12/4/19 and order dated 16/10/2018 otherwise are very similar in their contents. 16/10/18 being set aside by this court on the ground that there was no proper inquiry.
Yes.
Can we uphold 12/4/19?
Lordship.
If we cannot uphold 12/4/19,
Lordship.
does he have a case?
Lordship, at that time, the statement of the complainant was not recorded.
Yes, recorded.
Yes.
See,
not recorded.
I have perused the criminal complaint and also statement made by the complainant. He had done it on 16/10/2018 also.
That is complaint filed by the, it is not the.
I have perused the criminal complaint.
Yes.
That is the complaint file.
Yeah, that is only.
And also the statement made by the complainant. So he made a statement also.
That
Similarly,
is,
like this time.
Your Lordship, if I may, he was called for to appear before the trial court.
Yes.
And then he was just verbally examined, but not in written form at that time. So the magistrate taken cognizance, and then now on 2018 they came forward this. Then the record was sent back, and then he personally
We don't
examined
find here that it is the
complaint.
oral statement. I don't find it is an oral statement. Because on 21/5/2019 he is again recording statements. Why?
Yes, he went to another inquiry.
So can you have an inquiry after you issue summons, or do you have the inquiry before you issue the summons?
Yes. Before summoning the second.
He should have made the inquiry.
Yeah, yes.
Therefore 12/4/2019 goes.
Yes.
12/4/2019 goes, then the entire taking of cognizance goes. And he has to do it once again.
Yes,
It has to be remanded back to do it fairly and properly.
My lord, the same procedure, the same judge, the same court, they have adopted the same thing which are filed in 2018 without following, because the court, this honorable court said in 8th of March 2019, there is an irregularity. The same thing was done, my lord.
That is one part. Okay, I have understood one part of it. We will come to some conclusion on it.
Yes, my
What is your next submission?
Yes, my lord. And then based on this now, the issue of postponement, my lord, I'll place one judgment, my lord.
What is the next order? You are reading it. Page 79. This one. Where was that order of 12/4? Page number?
79. 79. Type copy. Page 79, book 1, your Lordship.
Page 79.
79, yes.
This was 12/4/2019.
All the prosecuting orders passed by the CGM was page 79 and 80 pertaining to this matter.
This is something I think Learned PP should also try to look into.
Yes.
Whether the order dated 12/4/19
Yes.
will be sustainable in law in view of the fact
Yes,
that 16/10/18,
Yes.
the earlier order which was this court had set aside, they are very similarly
Yes,
worded,
yes.
very similarly placed.
Maybe there are
And
some
if that was wrong,
irregularity.
if that was wrong, can we today hold that no, 12/4/19 is wrong? If we have to hold 12/4/19 to be wrong, then does the registering of the criminal complaint as of today go? If that is the position, then we have to remand the matter back to
Yes,
trial.
yes.
Now,
For
with the new development that the other witnesses have also been examined on 21/5/2019. On the next page, if you have the next page, take the next
yes,
page.
yes.
Now, other witnesses were examined.
Yes.
So now all the witnesses who were required to be examined for an inquiry has already been examined. What will be the effect of this examination on the complaint being freshly registered, or does it have to do entire
Re-examine.
he has to re-examine all over again?
Yes.
These are the 2 points that
Yes,
you would
yes.
perhaps require to clarify to me.
Yes.
Yes.
Now, my lord, as far as this issue of postponement is concerned,
Yes.
I'm placing this, the 2009-16 ACC 6110. This is Birla Corporation Limited and others versus Advanced Investment and Holding Private Limited, my lord.
Which paragraph?
I'll take you to the relevant paragraph, my lord. Page, the paragraph 9 is the allegation.
Allegation.
Yes. My lord, I'll not read it because.
Not necessary.
Yes, yes, my lord. I'll take you
Let
to
us
the
not
relevant paragraph, my lord.
Spend court time on this.
Yes, my lord.
And
My lord, the other is paragraph 25. There are 6 issues. I'm only concerned about only one, my lord. Yes. Where did the allegation, my lord, have that in page para 25?
just a minute, just give me.
Yes.
This is Birla Corporation Limited. This was not there in the earlier case. This was not considered in the earlier case. No. Okay. Para 25. What is?
Yes. I'm concerned only with about one issue, my lord. One consideration. That is whether the allegation in the complaint and the statement of the complaint and other materials before the magistrate were sufficient to constitute prima facie case to justify the satisfaction of magistrate in issuing process against the respondent. Because here
just a minute.
Yes.
Can you remove this pillow? Whether the allegations in the complaint and the statement of the complainant and other materials of the prima facie case to justify satisfaction of the magistrate to issue process against the respondents. Okay.
Because here some of the respondents where the magistrate had issued summon out beyond Calcutta. This Birla, this matter, the proceeding was taking place in Kolkata, but there are some respondents who are residing beyond the jurisdiction. So this is the question, this is the consideration I'm putting forth before this honorable court. So para 26, it talks about the complaint of under section 200 of CRPC, which I need not read, my lord. Then come to paragraph 29, my lord. The court has referred to one judgment, my lord. May I read, my lord? In Mahmood UI Rahman versus Khazir Muhammad Tanda and others, so and so. The scope of inquiry under 202 of the CRPC and the satisfaction of the magistrate for issuing of process has been considered and held as under, my lord. Chapter 15 of Code of Criminal Procedure deals with further procedure for dealing with complaints to magistrate. Under section 200 of CRPC, the magistrate taking cognizance of an offense on a complaint shall examine on all the complainant and the witnesses, if any, present, and the substance of such examination should be reduced to writing, and the same shall be signed by the complainant, the witnesses, and the magistrate. Now, under section 202 CRPC, the magistrate, if required, is empowered to either inquire into the case himself or direct an investigation to be made by a competent person for the purpose of deciding whether or not there is sufficient ground for proceeding if, after considering the statement recorded under section so-and-so and the result of the inquiry or the investigation under section so-and-so, the magistrate is of the opinion that there is no sufficient ground for proceeding, he should dismiss the complaint after briefly recording the reason for doing so. Now, chapter 16 of the CRPC deals with commencement of the proceeding before magistrate. If, in the opinion of the magistrate, taking cognizance of an offense, there is sufficient ground for proceeding, the magistrate has to issue process under 4204 clause 1 of CRPC for the attendance of the accused, so and so, my lord. So now, 30 is also relevant, my lord. 31 is relevant. Then, my lord, may I read 31?
31 we have read.
Yes. Beyond, this is to do with beyond the jurisdiction. Now, my lord, comes to 32, my lord. May I read, my lord? By the CRPC Amendment 2015 in Section 202 of the CRPC of the Principal Act with effect from 23rd June of 2026, 206 in subsection 1, the words "and shall" in a case where accused is residing a place beyond the area in which he exercised jurisdiction were inserted by section 19 of the CRPC Amendment Act 2005. In the opinion of the legislature, such amendment was necessary as false complaints are filed against persons residing in far-off place in order to harass them. The same is here. The same is before this court, my lord. The object of the amendment is to ensure that the person residing at far-off place are not harassed by filing false complaints, making it obligatory for the magistrate to inquire. Notes of clause 19 read as under: false complaints are filed against person residing at far-off places simply to harass them. In order to see that the innocent persons are not harassed by the unscrupulous person, this clause seeks to amend subsection 1 of section 202 to make it obligatory upon the magistrate that before summoning the accused residing beyond his jurisdiction, he shall inquire into the case himself, or direct investigation to be made by the police officer or by such other person as he think fit for finding out whether or not there was sufficient ground for proceeding against the accused. Nothing has been complied. Now,
okay, understood. We have gone through. If you are referring to any other paragraph, just let us know. We have gone through 31, 33, 34.
My lord, then 35, 36.
35, yes, I have gone.
My lord, even 36, my lord.
Okay, 36 also.
Yes.
And 37. At the stage of issuance of process.
Then my lord, 41.
Required based on the allegations.
My lord, 41. Paragraph 41.
It has been taken, cognizance has been taken under 406, 417 and 420. You have also to address us on that as to how, on the basis of the statement of the complainant taken on oath, how any offense under these sections can be said to have been.
Lordship, in one sentence, may I just compliment his the offense, the occurrence of offense is very much within the jurisdiction of this court. Or the person may be residing elsewhere, but the contract work is within the jurisdiction of the long line.
Yes.
So
understood. But what does the law say?
What
does the law say? The law says
yes
that the accused is residing at a place beyond the area. So that it is not where the contract took place or where the act took place. When the accused is beyond the area, then 202 comes into play.
Exactly. And yes, Lord, at that time, the accused number 4, Vinod Kumar, was there. He was the supervisor, he was the chief engineer.
He was still within the jurisdiction?
Yes, he has
when
been
the complaint was
for
made?
a long time. He has been, even he brought Mr. Amanan. He introduced me.
No. When the complaint.
My lord, the complaint is, may I interrupt? The complaint is 2018. Supreme Court has foreclosed in 2017 the contract. How will be there? Supreme Court has foreclosed the contract. Even physical presence.
That we will come to. Who was residing where is one issue we will have to find out from your petition. Whether you have made any declaration as to which applicant. See, I am not finishing the matter today because I am also going into a lot of questions. I came here yesterday and the weather change has not been very kind to me. So I'm just trying to formulate what we are going to discuss. If not today, tomorrow we are going to discuss. Day after tomorrow. Tomorrow is a division bench day, so no single bench. No single bench.
It's up to you.
I can take up a single bench if I want.
Yes, ma'am.
And day after tomorrow.
My lord, I'm outstation lawyer. I keep traveling from Delhi for this matter, my lord.
You have come from Delhi?
Yes, my lord, to argue this matter, my lord.
So, are you staying back today or are you want to return tomorrow?
Based on the proceeding, my lord. My lord, now this is another issue. So
because
now,
what I'm trying to say is this: even if we try to take up all your arguments today,
yes, ma'am.
He will also require some time to reply. I have to give him some time to reply. Because just now we are just not trying to discuss it. We are not framing our mind as of yet. We are just trying to find out what is the line we are going to take. Once you finish your arguments, You would like to
Is there,
reply?
Lordship?
How long you take?
No, only just 4 minutes. I have.
Okay, then we continue. So which
I don't know how
applicants?
long my mother is here.
No, I won't take much. There is only one issue left after this.
Ah, yes.
I'm sorry if my lord is not
No,
well.
no,
and
there's no
answers, my lord,
difficulty.
but
We appeared in courts when I was in this, so we'll conduct a court when I'm in this. No difficulty. Yes, so
my lord, in that judgment, that Berla judgment, if my
Yes.
lord not reads para 61, my lord, may I just read that, my lord? Para 61, my lord. I'll just close it with this, my lord.
Yes, yes.
As far as this section 202 is concerned, my lord. The object of the investigation under section 202 of CPC is for the purpose of deciding whether or not there is sufficient grounds for proceeding. The inquiry under 202 of CRPC is to ascertain the facts, whether the complaint has any valid foundation calling for issuing of process to the person complained against, or whether it is baseless one, on which no action needs to be taken. The law imposes a serious responsibility on the magistrate to decide if there is sufficient ground for proceeding against the accused. The issuing of process should not be mechanical, nor should be made as an instrument of harassment to the accused. As discussed earlier, issuance of process to the accused, calling upon them to appear in a criminal case is a serious matter, my lord. And lack of material particular and non-application of mind as to the material cannot be brushed aside on the ground that it is only a procedural irregularities. In the present case, the satisfaction of the magistrate in ordering issuance of process to a respondent is not well-founded, and the order summoning the accused cannot be sustained. The impugned order so-and-so, holding so-and-so, complaint so-and-so, and so-and-so, cannot substance and is liable to be set aside. Same as this matter, my lord.
Yes.
Nothing more, nothing less. Even the allegations 406, 417, 420 is the allegation, my lord. Now, there is only one issue left, my lord. Whether, when there is of contractuals, or let's say, if at all there is a dispute, it will be of civil, not of criminal, my lord. And then the respondent number 2 has already availed that civil, is pending
When
before.
did you file the suit? When did you file the suit?
Same, sir, same day. And the CGM has taken the same cognizance on the same day again, this CRPC, and then under money suit, my lord, CPC, the same judge, the same day.
And what is this ground H you are trying to rely upon? Ground H? I don't think you are impressing upon H much, are you? 7 at page 23 of the paper book.
Yes, my lord.
Paragraph H, you are trying to convince the court that under section 192, the CGM should not have taken both the suit and the complaint under him at the same time. That is
Yes,
what you are trying to
my
do.
lord, and it is triable by magistrate first class.
So he should have. Are you leveling aspirations on the CGM then?
My lord?
Are you trying to say that the CGM is not acting bona fide or he is acting with some? No, you are not trying to say that.
My lord, I don't want to come to that, my lord. I don't want to entangle in all these contentious issues, my lord.
Then we say that H is not being impressed upon by you much.
My lord, okay.
Save and accept to the fact that during the pendency of a suit, the CGM should have taken note that there is also a suit pending, and therefore whether we should proceed criminally in a criminal proceeding or not should have been considered by him.
Yes, my lord. Yes,
That is one part of which he should have applied. His mind is what we
yes,
will
my
try.
lord. Yes, my lord. Yes,
Try to answer if that is
Yes,
your
yes.
argument. Then you are talking of vague and frivolous allegations. Then it is without notice. Then M, 19M is what? Will you address us on 19M? At page 25. Anything on that? Or no?
And my lord, yes, my lord.
The ground M.
Yes, my lord.
I'm not supposed to keep reminding you what you want me to argue, yes?
Yes, my lord.
I'm reminding you what you should argue. Say, what is M?
Yes, my lord.
Anything on M?
Yes, my
Any
lord.
judgments? What?
Yes, my lord.
Show.
The first two work orders, my lord, if you see who has signed it, it is not me who has signed it. It is none of the petitioners who has signed it. It is someone else who is not before this honorable court. So I cannot speak on that behalf, my lord.
No. You are saying that the ingredients are not made out.
Ingredients are not made out, my lord.
Show me something on that.
When I don't have any dealings, my lord, how can some ingredients or this kind of allegation be put across a person on me, my lord? There is no documents. If you may I take it to the work order, my lord, if my lord permits? My lord, the respondent number 2 himself said in the complaint, in the criminal case, in the money suit, saying like he's a first-class contractor, my lord, he's a registered first-class contractor. When a work or tender is issued, when contract has been issued, there should be some design, there should be some specification, there should be some drawings, and what works to be done, nothing has been complied, my lord.
Save that for the suit. Save that for the suit. Yes, sir. Now you first convince me. State would like to proceed first, or sir proceeds? Sir.
The investigation is called. Then we have not much.
No.
Just on this 0202, yes, I admit, we acceded to them. So, but then
So probably
the irregularity is not fatal, Your Lordship. That's what I want to say. Because company's good office is clear, prima facie, and
Compliance of 200 and 202
yes.
has been held to be mandatory by the Honorable Supreme Court. It is fatal. Once you don't apply your mind or you don't inquire into it, it is fatal. Taking cognizance is fatal, but not to the extent that it will never proceed again. A reconsideration can be done.
Yes,
now, in this case, an opportunity of reconsideration was given.
If an opportunity
So every time there is a wrong order, do we demand it back?
Yes.
Or do we have to give a quietus to it so that the suit can proceed?
That I leave it to Your Lordship.
Yes, sir. You convince me.
Lordship.
Anything else? Any judgment you want?
Yes,
to
my
say?
lord.
Yes, please.
As far as if there is a flavor of civil dispute, that criminality cannot come into play. So I'll use just some judgment.
I'll just take the judgments and then we'll go.
Yeah. There are lots, my lord.
You tell me the,
I'll not travel, my lord, much.
You tell me the para number?
Yes, my lord.
This is for criminal breach of trust. Okay, 406 and 420. Which para are you relying upon? Scope of it.
Just give in chronological order like that, and then I'll send it out. My lord, have that Delhi race course?
Delhi Race Club, yes.
Yes, my lord.
Yes.
May I just say the paragraph number then, my lord, without troubling your lordship, or you want me to?
Just give me the para numbers, I'll read it.
Okay, my lord. Then, my lord, paragraph 10 to 13 is just the facts, my lord.
Okay.
Yes. Then 14, 15. My lord, 20, 21, 22, 23.
21, 22, 23.
36, 38.
Oh, you are again repeating the same judgments. MU is what I read, na? Para 20.
Yes, my lord. Yes, my lord. Yes, my lord.
Then what did you say? After 23, what did you say?
36, my lord.
36.
38.
Just a minute. 36. 38.
Yes, and then 45, my lord. 41, my lord. I'm sorry.
Where is this Nagwana? Nagwana case is referred where? Okay. Okay, this is your second submission. Then this one.
Then, my lord, this.
Thermex?
Yeah, Thermex, my lord. The paragraph 3 is the facts, the whole facts. Then paragraph 10, 11, the contentions.
10, 11.
19, 20, 21, my lord.
19, 20, 21. 19,
Yes, my lord.
20 and 21. Okay. And
Now, my lord, Paramjit Batra.
yes.
My lord, paragraph number 3 is facts, 7 and 9, my lord.
Okay. You have something more recent on this? Look into
These are all to do if there is civil dispute, the criminal law cannot come into place.
Okay.
My lord, visa holding is paragraph 2 and 9 only.
Sorry. Visa holding, okay. And
Yes, yes, my lord.
Rikha Birani.
Yes, Rika Bilani, my lord, 9 to 12 is the facts. 14, 17.
This is for what?
This is also regarding about
Whether ingredients are made out.
Yes, yes, and then if there is of civil nature, the criminal proceeding cannot drop into it.
What is the para number you are saying?
My lord,
Para numbers you are referring to?
9 to 12 is the facts, but 14, 17,
Just a minute. 14.
17 to 21, 17, 18, 19, 21, and then 27, my lord.
14, 17, 18, 19, 20, 21 and?
27, my lord. Then, my lord, SN, Vijay Lakshmi also, like, my lord, this all is also paragraph 33, 42, 43, my lord. 46, 47.
Sorry?
Paragraph 33.
Vijay Lakshmi is paragraph 33.
Yes, 42, 43.
33.
42,
42.
43. 46, 47, my lord.
Just a minute. 42. 43 and?
47, my lord.
47.
46, my lord, 46 is there, 46, 47, my lord.
46, okay, done.
Then, my lord, now this is to do with Sikar chemical. This is the Honorable Supreme Court recently has passed. My lord has gone through this judgment, my lord. Then I need not, my lord. Then I need not. This has been modified, my lord, in.
I know.
Yes.
That is what I was asking you. You should have the more recent one.
My lord.
So, in your arguments, if I can, you sum up your arguments, I'll just try to tell you what I have understood. One, procedure under 200 and 202 not being followed.
Yes.
We should interfere. And secondly, this being a civil dispute, we should not interfere. And thirdly, the offences are not made out.
Correct at all. Not made out.
On the basis of the complaint and the witnesses.
Yes, my lord.
A statement of the witnesses recorded on oath.
Yes, my lord. The witnesses said like they walked.
That is your. We'll go through the witness statement.
Yes, yes, yes.
We'll try to find. If he can show us. Yes, sir.
Deep love, my lord.
Yes, Lordship. Criminal and civil cases can go hand in hand.
Yes.
It is very much. There are so many Supreme Court rulings.
Give us one or two.
Lordship, I'm sorry right now, but
You give a list. You give a list by end of the day or tomorrow. When can you give?
next day.
Tomorrow. Okay. So you are saying criminal and civil can proceed simultaneously.
Yes, simultaneously.
Okay.
And in this case, pertaining to criminal here, now this is criminal breach of trust and cheating dishonestly, deceiving the complainant. That is what my criminal petition is. At the same time, in 2018, my learned friend has argued that they were far from places. But the head office has been set up at Zubza here in Nagaland. So they were stationed here.
That is the difficulty, sir. You have not even filed an affidavit in opposition trying to bring on record the presence of any such office. How can I take notice of what is being
That is
submitted already?
all those arguments. But let me just come to a very specific point. Here, this is a criminal petition which they have put forward.
Yes.
Now, here, on ground of maintainability,
Yes.
I strongly object,
Yes.
Lordship, in all fairness, in any criminal matter, the accused cannot authorize any person to represent him or her. And as such, on this ground alone, the instant criminal petition is not maintainable in the eye of law and is liable to be dismissed. Now here, he is putting up so many petitioners. In the Vaklatnama, there is only one, number 4. He was the only one person.
Is it?
Yes. This is his petition. So how can it be maintained in criminal cases? How can somebody endorse to one person that take my criminal cases on behalf of me? It cannot be. Criminal cases too, that person should bear.
He did not interrupt. You will do it at the last stage.
Yes.
Okay.
Your Lordship, and in the affidavit, Your Lordship
Yes.
may kindly turn to page his affidavit, page number 32.
Of the paper book.
Yeah, paper book, Your Lordship. Paper book says
You
that-
say Vakalatnama only of one person.
Yes, only Vinod Kumar. Here, may I read their affidavit, Your Lordship?
Yes,
I,
page
A.S. Vinod Kumar, son of so and so, about 35 years. At
Page
present-
30? Page?
32, Your Lordship.
32. Yes, yes.
Yes. Here, Midas, project manager Midas Sky3 Project Limited, residing at 638 Ravi Street, Nagaland District, Andhra Pradesh, so and so, presently at Kohima, Nagaland, do hereby solemnly affirm on oath and declare as follows. Here, Your Lordship, in the first para, I have also been duly authorized by the petitioner 1, 2, 3. There is no authorization letter also in the petition. How could we just presume that he has been authorized? And in the criminal cases, how could it be authorized to represent another person? That is my contention. Lord, without going through all the evidence, this case should be thrown out. And this honorable court need not to intervene. That is one point. Lordship, only one Mr. Vinod Kumar signed the Vaklatnama in this complaint petition. Criminal petition, I mean, Lordship, I'm sorry. And then secondly, the counsels were not authorized to represent the petitioners 1, 2, 3, as it is evident on the perusal of the Vaklatnama filed by the petitioner number 4. How could he represent? Only he's representing number 4, then that's fine. But how about 2, 1, 2, 3? That's my point, Your Lordship. And thirdly, it is not permissible for the petitioner or the accused in my complaint case, number 4, to swear an oath on behalf of the petitioner 1, 2, 3. How could he swear an affidavit on behalf of other 1, 2, 3? And now, fourthly, Your Lordship, it is not maintainable on the ground that the petitioner, number 4, cannot represent the petitioner, number 1, 2, and 3. Your Lordship, this is a criminal case. How could he represent?
We understand.
And fifthly, this instant criminal petition is not maintainable at all because the petitioner number 1, 2, 3 have not approached this honorable court so far. See, they have no Vaklatnama. How could number 4 only represented? They have not approached. So outrightly, this petition should not be entertained and sent back to the
What about
and Your Lordship,
as
one
against-
last point. Your Lordship, here, the present criminal petition number 5, 2019, even if assuming but not admitting, is maintainable only in respect of petition number 4. However, it should not be a ground to quash the order, summons, and proceeding of learned Chief Judicial Magistrate dated 12/4/2019 and 21/5/2019 in CR case 1 of 2018 filed and pending before trial court Longlang, Nagaland, because it is a composite matter and it relates to all the petitioners accused 1 to 3 as well, and as such, in all fairness, it cannot be quashed in piecemeal. Lastly, Your Lordship, the
Just a
present criminal
minute,
petition.
not quash it in piecemeal manner.
Yes.
Okay. And yes.
Yes, there are so many points, but I don't want to go there. My point is limited. That I have taken
On the
a lot of time.
maintainability part.
Yes, so I'm saying that this criminal petition is not maintainable, and the interference of this honorable court is not called for. It's not necessary. So kindly, my humble prayer is, please send back the case to the trial court, let the trial court proceed, and let them prove their innocency. If they have any, then let them come and prove. Doesn't matter.
Tell me one more thing.
Yes, Lordship.
Just tell me one more thing. This can proceed, this criminal petition, so far as it is,
So far as
it
my
relates
submission
to,
is, Lordship,
yes.
the magistrate has taken good step. He has already
we will
taken
record
all the steps. 202.
What I am trying to understand is it is maintainable by the respondent number 4 in its present form.
Yeah, maybe
by
if-
not the others.
not by the
Now,
others.
if the respondent number 4 shows the court some such ground which is by which he can get relief because of the illegality or whatever in the order, can this court shut eyes to say that no, we will do it only for him, not for others?
Lordship,
Or that order has to go in the
this is
whole.
a composite case, as I mentioned.
Composite case is what you
Yes, composite case. So one.
And what do you
accused-
say to his submissions on this 200 and 202?
Yes, it's already been satisfied, followed by the learned Chief Judicial Magistrate, and all the orders are in page 79.
And would you
All
like
the
to-
orders proceedings are there.
Would you like to refer to any part of the evidence or the statement on oath recorded by the CJM at the first instance to show that the ingredients of 406, 417 or 420 are even indicated in the complaint or in the statement?
Now, in his complaint petition,
yes,
Lordship, it has already been stated that this Midas Kaidre joint venture has cheated him, dishonestly deceived him.
Simply saying cheated is not going to
Yes.
help.
Yes, but it is a complex statement out there, Your Lordship.
Yes. Let us have that statement at page 81.
Yes.
Where is the ingredient of cheating? What is the ingredient of cheating? IPC. Sir, IPC. Give us the ingredients of cheating. Because he has relied upon judgments, I have to give some answer to whatever he has relied upon. Take a seat. We'll listen to you, don't worry. We'll listen to you. We still have 15 minutes. We'll listen to you, don't worry. Yes, sir. What is the ingredient of 406? What should we have? 406 or 405? Ingredients. Yes, show us some judgment on the ingredients, sir.
My Lord.
So for 406, we must have entrustment with property, dominion over property, dishonestly misappropriates or converts to his own use. Where has he said so? That there was some entrustment. We will only go by the statements made. We will not look into the correctness or the otherwise of it. We'll just try to find out
Yes.
for your benefit.
Lordship, the statement,
Page
complaint,
81.
Page 88, 88.
Page 88.
Yes, this is the complaint. Now may I read? Para 8,
Yes.
1, 2, 3, 4, 5.
Yes.
Para 6, Your Lordship. That for the release of payment, I have communicated to them on several occasions, even served legal notices through my legal counsel, but till date they did not make any effort to contact me or to make payment of the outstanding bill. In fact, the company Maida Sky 3 joint venture have dishonestly and deceitfully cheated on me for their unjust and selfish end, and for which they deserve befitting punishment as per the law of the land. I therefore pray your honor to take necessary action against them in the interest and for the ends of justice and for. So that is what they have done to me. If we, Your Lordship, go by the evidence, once they have deposited 25 lakh in my account, and that also even Mr. Vinod Kumar, serial number 4, has siphoned away even 8 lakhs out of that also. See, this number 4, but that will go to the trial, Your Lordship. I don't want to place all the merits of the case.
I am not on what good evidence you may have at the trial. I cannot go into that.
Yes, Lordship.
You have said in your complaint that as per terms and conditions of the work order, I started executing the work and submitted bill.
Yes.
Due to non-payment of bill, I am facing immense financial.
Yes.
After this part payment, they never made any further part payment, but kept assuring me that they will do. Okay. And in your
And even they have.
you have said. Okay. Now, sir, you explain to me how it is maintainable against. So that will be all. You want to give some judgments. By when will you give it?
Lordship, I'll try to get a week.
Week? I'm not here for a week. He needs a judgment. How? You don't have to be here. You can just give me the judgment.
Okay, Your Lordship, then I'll give you a judgment. Supreme Court of India Criminal Appellate Book.
Oh, you're giving me some
Yeah,
citation?
Yes.
Okay. Yes, please.
Case number I'll give, Lordship. Criminal Appeal.
Criminal Appeal
255.
255.
2019.
2019.
Arising out of ASLB criminal numbers.
No, can your colleague help me with the printout? Can you help me with the printout?
Yes, Your Lordship.
You give me the printouts of the judgments you want to rely upon?
After some time, Your Lordship.
Yes.
Yes. Citation So Kumar Shivaji.
Any number you want to give, you give your, but kindly you put down the paragraphs that you want to refer to so that I can go through them.
Sure, Your Lordship.
Right. Yes, satisfy me on
My Lord.
that it is
I'm so
maintainable
grateful.
by the 1, 2 and 3, nothing
Yes,
else.
my Lord, I'm so grateful about the according me this short rebuttal. My Lord, I thought like I will end up my argument with some short thing, but my Lord, I have
You wanted
submitted.
a summing up? Do.
No, my Lord.
You have 7 minutes.
Yes, my Lord. Now I have submitted one judgment.
Yes.
SN Vijay Lakshmi, my Lord, state of Karnataka and so on. So, my Lord, have that. My Lord, may kindly have that judgment. I'll answer to that regarding the
Vijay Lakshmi, yes.
Yes, my Lord.
Yes.
My Lord, may kindly come to para number 48, my Lord.
Para
8, my Lord. May I read it, my Lord?
Ah.
It is required to be
Have
clear.
you given him a copy?
No, my Lord. I'll hand over, my Lord. I'll hand over. It is, may I read, my Lord? It is required to be clarified that though co-accused Vidyasri V.S., the daughter of the appellant number 1, is not in appeal, my Lord, for reason best known to us, yet, as all the accused stands on the same footing, and we have already quashed the proceeding against the appellant, in the interest of justice, the benefit of quashing Supra will ensure the benefit of Sri Vidyasri, as and so on. So parity would so demand, in fact, and circumstances, so as to serve the cause of justice in Pawan, so and so, my Lord, so and so. Now, in the like circumstances, or just above that, the court exercised suo motu power to deliver justice to affected parties not before it, my lord.
That was a
In the
case-
circumstances, albeit, yes, my lord.
That is a case where the parties were not before it.
Yes, my lord. But even here in this matter, my lord, if at all, if we take the argument of my learned
If we hold
counsel,
that it is not maintainable, this revision petition is not maintainable by
Yes, it's not
1, 2
maintainable
and
at all.
3, what is the consequence then is what I'm trying to understand.
yes, my lord, if the petition is quashed in favor of petition number 4, all 3 will go. Even a person who is not before this honorable court can be quashed by this honorable court judgment 6, paragraph 48 says.
Yes,
What
sir.
more can I say, my lord?
That is what I'm trying to ask you.
What more can I say, my lord?
Suppose
Yes,
this summon is, suppose it is found to be illegal against respondent number 4, applicant number 4, then will not the entire summon go? Or it will remain against 1, 2 and 3 and only against 4 it will go? Or just because 1, 2 and 3 have not approached correctly, therefore 4 also has to suffer?
You see, it is a company, Your Lordship.
My lord, I'm just submitting one more judgment in my favor, my lord. I thought I'll risk.
I'll go through it. I'll go through it. No, I'll go through it. It's just, I'll go through it. Please continue.
Number 4, petition number 4 is working under that company. So the executing work is for the company. He's only representing the company.
Yes.
So all the burdens lie or liability be upon the company. Say 1, 2, 3, as I have already made them as accused in my complaint petition. And in this petition, you see, all these other 3s are not coming forward.
You are talking of vicarious liability then? No. What?
Only-
The servant, the respondent number 4, if he has done some mischief, then all the 3 will also be. That is what
No,
you're trying to say. That is what you're trying to say.
also, Lordship.
Then what are you trying to say? Then I'm not understood you. Can you repeat your arguments?
Lordship, this criminal case is only filed by the petitioners.
Yes.
3 of them.
Yes.
But he says that he has duly authorized. But
There is
where is the
no authorization.
authorization letter? Nothing is there in the petition. Your Lordship may peruse there. If I don't see, then I don't know. But it is not there
I have also not
in the
found it.
affidavit. And in criminal case, no one can authorize anybody to fight a case against on his or her behalf. How could these 3 people come and, endorse Mr. So-and-so to, you fight my criminal case? Lordship, sometimes it is funny, but it's a fact.
I understand.
So I'm saying that the rest, other than 4, they did not approach this honorable court till date. They don't have any,
How many are here?
they did not file even Baklatnama.
3, 2, 4. Okay.
So without going through the merit of the case, that is my only case. And the case is a composite case. So in Bismil, this case cannot be decided.
So arguments heard, Mr.
Likang Michael, my lord.
For the petitioners and also heard, Mr.
M. Kasar.
And
M. Kasar. K-A-S.
And Ms. So-and-so, Leonard PP. Mr. Kasar appearing for the respondent number 2, Leonard PP for the respondent number 1. Arguments have been heard and concluded. Judgment. What do you say here? CAB? What do you say?
Simply reserved.
Huh? Judgment reserved. Judgment reserved. We should have it. In a day or 2, we'll try to finish it up.
I'm deeply obliged, my lord. Despite your help.
You have come down from Delhi.
Yes, my lord.
So how many years of practice you have?
My lord, 12 years running, my lord.
12 years and okay.
So oblige me.
Oblige, my lord.
You give your list of
Yes,
books
my
and if possible printouts.
Yes, print out, definitely.
Spelling out the para numbers.
Yes, yes.
Paragraph number.
Lordship, definitely.
So,
Right after.
okay. Done for the day. Or तो नहीं है कुछ? Anything remain? No. All right. Thank you.